7 p.m. Time and date set for proceedings in this matter. Parties are present. Would you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yeah.
Thank you. You may put your hands down. Sir, I'll begin with you. Your name is Adam M. Gonzalez.
Yes.
You are the plaintiff in this matter, correct?
Yes.
Have you lived in the county of Huron at least 10 days, in the state of Michigan at least 180 days, immediately preceding your filing this complaint for divorce?
Yes.
At the time you filed this complaint for divorce, was your spouse also a resident of Huron County?
Yes.
Is it true that you were married on August 12, 2022 in Bad Axe, Michigan by a person authorized to perform marriages in the state?
Yes.
Are you still living together? According to your complaint, you were. Have you since separated?
Yeah, we're at 2 different addresses now.
Okay, and when did that occur? Just
April.
of this year?
Yeah.
Very well. You've always been known as Adam Michael Gonzalez, and your spouse was formerly known as Christina M. Berry, B-I-E-R-I. Is that correct?
Yes.
There's one minor child in this marriage, correct?
Yes.
And that's BMG, who's age 1.
Yes.
As far as you know, is your spouse currently expecting?
No.
You've alleged in your complaint for divorce that there's been a breakdown in the marriage relationship to the extent the objects of matrimony have been destroyed and there remains no reasonable likelihood the marriage could be preserved. Was that true at the time you filed the complaint?
Yes.
Still true today?
Yes.
Briefly, in your own words, can you state to the court why you feel the marriage cannot be preserved?
Just not getting along. It's not there.
Fair enough. Is there any chance of reconciliation?
No.
If the court did not grant you an absolute judgment of divorce in this matter, would you be willing to resume a husband-wife relationship with your spouse? So I asked off the record prior to calling this case of whether or not the parties had reached an agreement regarding BMG, and my understanding was yes, you did. And number 2 is that it was based upon the interim order that was previously placed in this file. Is that correct?
Yes.
Okay, so what that means, as I understand it, it would mean that the parties would have joint physical custody of BMG, but mother would have sole legal. Is that correct?
Yes.
And parenting time is according to the addendum that was filed in this case, again, back on August 22nd, which would mean that you have parenting time with the minor child on alternate weekends year-round from Friday to Sunday. Exchange time shall occur as the parties mutually agree. Is that correct? Yes. And that the holiday schedule each year shall be mutually agreed upon by the parties. If you cannot agree, the parties shall be granted alternate holidays each year, with whichever parent had the minor child for the prior year holiday, the other parent shall have in the current year.
Yeah.
Child support would be payable by you to mother in the amount of $228 a month, effective April 16th this year. Is that correct?
Yes.
Okay. 228. Communication shall be limited to matters for the benefit of the child only, correct?
Yes.
As to transportation, you shall transport the minor child to defendant's home at the start of preparing time. Plaintiff, you shall also pick up the minor child from the defendant's home at the start of your parenting time. Is that correct?
Yes.
As for income tax deductions or exemptions, the defendant, Christina M. Gonzalez, may claim child as her dependent each year. Is that correct?
Yes.
And again, you feel this arrangement is the best interest of BMG?
Yes.
Okay. As to hospital expenses, insurance, standard clause would be provided, correct?
Yes.
Okay. And you understand that the minor child cannot be removed from the state of Michigan, the domicile of the minor child may not be removed from the state of Michigan without prior approval of the court.
Yes.
And is it also true that neither party would be awarded spousal support and that issue is forever barred, correct?
Yes.
Is it also agreed that neither party shall move more than 100 miles away from the child's current address?
Yes.
Has the personal property already been divided that has been acquired during the marriage?
No.
What needs to go to who?
As far as I know, it's straight on the F-250 was under me.
Oh, I'm sorry?
The F-250 was supposed to come into
Okay,
me.
so you were to get the pickup truck?
Yes.
Are there any other motor vehicles?
No,
What about personal effects, furniture?
we already divided that.
That up has already been done. All the jewelry, whatever, has been divided as well?
Yeah.
Are there any debts to be divided?
No,
Are there debts in joint in both names?
no,
But each party be responsible to pay the debt in their respective. If you have a credit card in your name, it's your responsibility. If she does, it's in her name. You have the F-250 currently?
yes.
Whose name's on the side? How's that going to be changed?
We can go to Secretary of State.
Is there money owing on the F-250
No, it's paid off.
regarding the vehicle?
Yes.
Do you own any land?
No,
A home, cottage,
no,
lot, anything? Either of you have any pensions, annuities, or retirement accounts or life insurance carrying cash value?
no,
Are there any other assets or any other debts that you're aware of that we've not addressed?
no.
Your name is Christina M. Gonzalez,
Yes.
and you are the defendant in this matter, correct?
Yes.
Did you hear everything that was placed on the record relative to the property division as well as custody and parenting time of BMG?
Yes.
And is that your understanding of the agreement that's been reached?
Yeah.
Anyone force you into this agreement?
No.
This is of your own free will as well? And most importantly, do you think the custody and parenting time arrangement is in the best interest of your minor child?
Yes.
Are you aware of any other assets or debts that have not been addressed in this matter?
No.
Do you wish to change your surname?
No.
No? All right. Well, based upon the testimony presented, the court finds that the statutory grounds for divorce have been established. Therefore, a judgment of absolute divorce is granted to the plaintiff in this matter, Adam M. Gonzalez, from the defendant, Christina M. Gonzalez. With that in mind, as to most importantly, BMG, the party shall have joint physical custody of the minor child. Legal custody is awarded to mother. The court finds that this is in the best interest of the minor child. Neither party shall remove the domicile of the minor child from the state of Michigan without prior approval of the court. Also, no more than 100 miles away from the current address. Each party is obligated to keep the friend of the court notified of any change of address or employment. So if you change your job or you move, you must notify each of you, the friend of the court, of that, so that it can stay up to date. Regarding support in this matter, father shall pay support to defendant in the amount of $228 a month, which is already in effect as of April 2024, April 16th, as a matter of fact. Father shall have parenting time or custodial time as outlined on the record. Neither party is awarded spousal support. The divorce judgment shall include the property division that was outlined on the record, as well as any and all provisions regarding pensions, life insurance, and standard medical insurance provision. And that shall conclude it. What will happen next is I will finish out this judgment. You just have to fill out a couple of portions. I will then provide it to Ms. Hatch, our court administrator. She will then take it to the county clerk's office as fact after it's checked by the clerks. And once that is checked and everything is acceptable, it'll be filed with the clerk of the court. You'll be able to get your copies today and move forward. Now, just one piece of advice to both of you. I don't know what differences there are regarding each of you as to each other, but at the very end of this, you have a 1-year-old child, and you have to be absolutely unified when it comes to the best interest of that child. So if there are disputes or problems, talk about them, but not in front of the child. Don't say anything bad about the other parent. There's no need for that. Your child is a sponge and he's going to be soaking all this stuff up. We want him to be just as successful as both of you. Mrs. Schultz.
As to child support, Your Honor, the court is preserving any errors that exist on the records of the front of the court.
Yes, I would. 2-6 key. This is Mr. Parrott's motion as petitioner seeking a personal protection order against the respondent in this matter. Both parties are present. Mr. Parrott appears in person. Ms. Betty appears by the Zoom application. Back on history. Back on or about October 2nd of this year, the petitioner, Mr. Parent, had filed a motion requesting an ex parte personal protection order. After the court had the opportunity to review it, the court found insufficient allegations presented to authorize a personal protection order. However, the petitioner has the right to seek a hearing in this matter, and that's why he's here. Will both parties please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am.
Yes.
Thank you. Both of you put your hands down. Mr. Parent, it is your burden of proof to establish why a personal protection order should be ordered in this case. Please explain to the court why you feel one is warranted here.
Yes, Your Honor. Me and Miss Beatty lived together in my home for approximately 9 weeks, and the relationship deteriorated. Miss Beatty left. Miss Beatty has left some personal property at my home. There was a message, a voice message sent to a family member of mine where she stated that she had rights to the home and that she would be coming to get her things back. I would like you to know that with my time in the service and some of the disabilities and injuries I have, I took that as a true threat to my home, that people would come to my home to get these things. I would like you to know I have brought a video from my GoPro of all of Miss Beatty's things. They are in my home. They are in the basement. They are stored. Nothing has been damaged. They are there. Because of the, I want to say, threat of I'm coming to get my stuff. I have rights to your home. I have not been sleeping. I will tell you, sir, I used to have 4 cameras viewing the outside of my home. I now have 10, and I have 6 cameras in the home. My phone is over there right now with a view of the outside of my house, hoping that no one realizes Raymond's not home. He's in court. I don't even feel safe in my home. My family, with everything that is going on, has no ability to help me get her things out of my home. I do want them gone. I would love for a third-party company to show up and take them and go. But her threat of, I have residency rights to your home and I am coming back to get my things. Sir, I will not get into what it is I have done and given to my country, but I will tell you, and I won't because my parents are in here, I will tell you, I have fought my way out of a couple rooms. My home is the only place I'm safe. Comment made. There are times I don't feel safe there, and I have 16 cameras watching me now. I am asking the court for this personal protection order as there's other parts of this as it gets finished up. And I'm asking it to include not to contact my family about this, not to contact anyone associated with me about this, and in the end, to contact a third, like the 2 men in a truck people or whatever, contact an outside company, have the court say this company can come to the house and get the things. Your Honor, it is a 6-minute video that I took of her things. I would like you to know I have gone as far as take sheets and cover up the stuff that she has left in my basement so that it does not get dusty or dirty. I have shown the utmost respect for the possessions she's left in my home. I wish to God she could come get them tomorrow. But the threat of, I have residency rights to your home and I'm coming back to get my things. I have, if the court doesn't believe me, I even have that voice message that a family member has saved.
I received the message.
My little sister, and I will tell you, Your Honor, the part with this is my family has been so rocked by what has been going on here in speaking to my family, it truly is to the point her name cannot, because of what it's doing to me, her name to speak to my family for help and counseling, her name cannot even be mentioned to my family without my family members breaking down. They have no ability to deal with her because of everything that has happened. I'm asking the court to put this in place to protect me, to protect my family, to protect my home, and to tell Miss Beatty, you are more than welcome to your things. Contact an outside company, send them to Mr. Parent's home, he'll open the door, let him in, you can have all your stuff and your honor. I have my GoPro in my pocket, I really can give it to you to watch. She has 2 piles of things, big furnitures and like dressers and stuff, and then she has a pile of totes. And I kid you not, Your Honor, I went down there and covered them with sheets because I didn't want her possessions to get all dusty and dirty. She doesn't have a lot of possessions, but I understand they are important to her. I want to make sure she gets them back. I want to make sure that they are given to her and she can go on with her life. To have the threat of her saying, I have rights to that home, I'm coming back to get my stuff. I have gone days not sleeping because I can't take my eyes off the cameras that are watching my house. And me being here right now, I have 2 different people guarding my home. My neighbor across the street is watching it, and the people down the street are also watching my home versus the camera system that is on my phone that I've been sitting there viewing since the moment I walked in here.
Thank you, sir. Ms. Betty, do you have a response?
Yes, Your Honor, I would like to speak on this. I have contacted the Huron County Sheriff 3 times to get my belongings from Mr. Parent's home, and I've chickened out each time because I am a little nervous with everything, the other case going on, Your Honor. I would like to get my belongings from Mr. Parent's home. I'm just kind of waiting for things to cool down, and to be honest, Your Honor, I don't feel safe even in the area because of all the accusations that continue to come out. I have not, the only thing I've ever said to his sister was the day of the incident. I just told her that I had pictures of my belongings and that I will be back, but when it's appropriate, Your Honor. I have no reason to harass, to be near Mr. Parent, considering what's going on with the other case, Your Honor. And then from my understanding, there already is a PPO, considering with the domestic violence and all the other charges against Mr. Parent, that there's a PPO against him and I already. So I don't feel that there should be another one. I don't know how that even works, Your Honor. But considering that with me being the victim here from the domestic violence, there's already a PPO from the state of Michigan against each other. So, I mean, I've fully been abiding to that, as he has too. I've not heard from Mr. Parent. And I mean, I really don't know what else to say, Your Honor, except I do want my belongings. I want this nightmare to be completely over. And I'm just doing my best to bounce back, per se, Your Honor.
Well, Mr. Parent sounds like he wants this property out for his sanity and for his family's sanity as well. So
absolutely.
My question to you would be, if a civil standby can be arranged where it's only law enforcement there and a third party, because the court is aware and the court takes judicial notice of its other files.
Yes.
There's currently a criminal charge against Mr. Parent. There's a no contact provision. Also, that says not to have any direct or indirect contact with you.
Correct.
So is there a third party that you can give a name here that Mr. Parent may know that we can arrange to get that property out so we can get some peace to both of you?
When you say third party, do you mean like another family member of mine, Your Honor, or
Family member, a friend that is trusted, that can retrieve the property?
You'd have to ask Mr. Parent who he felt comfortable with getting my belongings, because he didn't trust me or any of my family even while I was dating. So if whatever Mr. Parent felt comfortable, yes, Your Honor, I would love to arrange that so that he could feel like he has his home back. Yes, Your Honor.
Mr. Parent, is there anyone that would be able to assist in getting that property out to a third party so that it can be brought to Ms. Betty? And then you don't have to worry about any of her stuff being in your home anymore? That you trust.
Sir, when it comes to Mrs. Betty's family members, I know that she has 3 daughters. I can tell you that in meeting her 3 daughters while we were dating, I was very uncomfortable with.
Well, not her family, your family.
My family.
Yeah, there's someone in your family that would be able to assist in getting this stuff loaded, let's say into a truck or something, and then get it out of your location to another location where someone from Ms. Betty's family can pick it up.
Your Honor, my family consists of my 70-year-old father, his back injured, consists of my, I think mom is 64 or 65, and my 42-year-old sister. I would never be able to put them in harm's way with the way this has affected my family. And I will tell you, Your Honor, even the other day in speaking to my sister about what it is I'm going through and working through, my little sister broke down and said, I love you, but I can't talk to you about this anymore until we get through it. I would like you to know that for the court case that we have mentioned and the accusations that have been.
Don't go there.
Right.
Don't, Mr. Parent, I'm just going to stop you because there's a pending criminal charge against you.
Yes, sir.
I don't know anything about it other than what has been charged. And anything you say could and will be used against you in a court of law.
Yes,
You're under oath, so
yes,
I wouldn't comment about that.
Yes, sir.
Let your attorney do the talking
For
for you.
using my family, I believe it would be a huge mental strain on them.
Do you know of anyone outside your family? A friend?
I don't have any, Your Honor. I have myself. I would like you to know, Your Honor, my choice in this life really was Uncle Sam. And when I got injured and ended up back out here, I spent every day wishing I could undo my injury and go home. And home is Uncle Sam. I will tell you, if guys from the 3 Men in a Truck people pulled up in my driveway, I would greet them with a smile on my face and say, gentlemen, everything she owns is in the basement right here and right here.
Hey, that's an idea.
Can she?
Hold on to that thought. Ms. Betty, is there a moving company? Because it sounds like there are a couple large dressers and a number of bins.
It's big.
Is there a company, whether in your neck of the woods or around here, that would be willing to do it? It'd obviously be your cost to retrieve it, but at least you'd be able to.
That. Your Honor, I couldn't afford that, even if there was, Your Honor. I do have some friends that would, if Mr. Parent put it out in his driveway, they would just come pick it up. And even if he needed the Huron County there, they would come pick it up, not even speak to him and leave, Your Honor. I could have that arranged.
Believe me, I would definitely make sure law enforcement is there.
Yes,
for
sir.
Everyone.
Absolutely.
Your
But
Honor,
what I'm saying is I have people that are willing to go do it without me there, which I prefer as well, to be totally honest. And
Who are the people that you are suggesting?
are you asking me, Your Honor?
Yes.
Their name is Lisa and Bill Zeller.
Bill Zeller, Zeller.
Correct, Your Honor.
And
I would
they're
have-
just yours?
They're friends, like family, sir. Yes.
Okay. Do you know if Mr. Parent knows these individuals or met
No,
them?
he does not know them, Your Honor. No, sir. But I tell you, they would just be very humble. They would get the pile and they would leave, Your Honor.
So you're proposing whatever date can be arranged, that the property be placed basically at the curbside. Here would be the roadside.
That's fine, Your Honor. Right in the end of the driveway would be fine. That's fine.
And you would not be.
Your Honor, yes, sir. If you tell me, Raymond, on this date and at this time, you have everything set outside, I will tell you, I will have everything in a pile, not a pile, I apologize for that
No,
word.
you're fine.
I will have everything, but here's the problem too. Please, don't make it on a Monday, that's garbage day, they come by and pick everything up. But if you tell me on this date, have everything outside in your driveway at 1 o'clock, and they will be there at 2 o'clock to pick it up, I swear to you, Your Honor, everything that, and Your Honor, I'd like you to know that when Miss Beatty left my home, there was knickknacks and there was breakables and kitchen stuff left. I went to Walmart, bought boxes and wrapping paper. I wrapped up all her things and packed them away to show politeness and courteousness, and I have that if it needs to be seen. But if you
I'm
tell
taking you at
me,
your word, sir. You're under oath.
if you
Your
tell
Honor,
me,
Your Honor, I would like to also state that I would have to talk to Mr. Zeller because he does work, and I would have to make sure it's a day that he has off, and I could correspond that with you, Your Honor, in the next 24 hours.
Is he able to be reached by phone today?
I don't think so, Your Honor.
Can you try?
I could try to get a hold of his wife.
Why
I don't know
you do
his
that?
right now.
Yes. I'll call another case. And then once you're back on, just let us know you're back on and we'll bring you back into the courtroom. We can get this thing wrapped up.
I will have everything out there, sir, Your Honor.
There's no issue with that. I just need to know from from Ms. Betty, when this could be done. So can you do that?
Can we do next Thursday, Your Honor? I know he has Thursdays off. Let's just aim for next Thursday. Does that sound efficient?
Your Honor, at Thursday, on Thursday, I will have to check what's going on downstairs, but on Thursday, 10 o'clock in the morning, I will start bringing everything up out of my basement that she owns. It should take me about let's say 2.5 hours. There's some big stuff down there. I got a dolly all the way up the stairs. I will tell you at 1 o'clock on Thursday, everything that Miss Beatty has left in my home
We'll be there.
will be sitting out in the driveway for someone to pick up. I will tell you that I will be locked in my home and I will not exit my home the rest of that day, and I will be locked in my home. It's unfortunate that it'll be out of fear, but I will not speak to anyone. I will not engage anyone. At 12:30, everything will be there. If somebody shows up at 1 o'clock to take all that stuff away, I'll never see him again.
Perfect. Ms. Betty, any objection to that?
No, Your Honor, that sounds perfect.
Perfect. Okay. Mr. Parent, just to let you know again, the names are Bill and Lisa Zeller.
I'm never gonna see him, sir.
Oh, I know, but I just want to let you know.
Yes, sir.
That's the name. Those are the names. So that'll be arranged next Thursday.
Well, the Huron County will be there, so they feel comfortable, Your Honor.
They should be there, and that is going to be your responsibility, Ms. Betty, to contact the sheriff's office.
What date is next Thursday?
Next Thursday will be October 24th.
October 24th. I will write this down. And Your Honor, like I said, I get up in the morning, I take my service dog for her walk. I will start taking the things out of my home at 10 o'clock. 2 hours it should take me, but let me have that little bit of half hour.
Yep.
If they pull up at 1 o'clock PM, everything will be sitting out there.
Perfect.
I would just like it removed from, and I'm gonna leave it back a little bit from, I'm not gonna like stack it at the edge of my driveway.
Right, it's
I'm
on.
gonna leave it back just a little bit so people don't think it's trash. I want her to have her belongings back. I know that they are important to
And that
her.
will provide you peace of mind.
Thank you, sir.
Ms. Betty, does that work?
Absolutely, Your Honor.
You are responsible, Ms. Betty, for contacting the sheriff's office.
Yeah, absolutely. Yes, sir.
What township would that be in Hume? That's Lake.
I live in Hume
Hume
Township.
Township.
Yes, Your Honor.
Okay, there's no Hume Township police officer, just Port Austin Township. So, Ms. Betty, you will have to contact Central Dispatch and make that arrangement.
Is that the Huron County Sheriff's Department, Your Honor?
Yes, or the state police one, but
They'll help me, sure.
state police would be a little more difficult to reach, but the sheriff's office is very good about doing this, so long as they're not backed up with other complaints.
Absolutely.
So
Yes, sir.
that's what we'll do. Next Thursday, 10 a.m., we'll start the movement of the property. Give or take 2 hours or so, 12, 12:30. Property will be there, set back a little bit. Mr. and Mrs. Zeller will be there to pick it up with Sheriff's Department standby. Mr. Parent says he's going to remain in his home.
I will be.
And by no contact, this will make this easy and everyone will have final peace of mind.
Yes, sir.
Now,
Appreciate you.
here's the issue though regarding the personal protection order request. It is the petitioner's responsibility to show by burden of proof, preponderance of the evidence, that more than likely or likely more than not, this type of activity, prohibited activity, will happen. There are a couple of things against that. Number one, there is a current pretrial release order against the petitioner in this matter regarding Ms. Betty. There's to be no contact. I'm not seeing any contact by Mr. Parent at all in any violation regarding that. So that's wonderful. That's number one. Number two is this has to be a repeated course of contact. There's been no contact alleged other than what has been alleged in the complaint in this matter. As a result, the petition for personal protection order is respectfully denied. However, the court is holding both parties duty bound under oath to the procedure to be done next Thursday. And yes, the 24th of October, and that will wrap it up.
Thank you, Your Honor.
Mr. Parent, do you have any questions?
Your Honor, the no contact order that you have referenced, that also includes not contacting, they said third parties, so that includes not contacting my family, correct?
No, it's the opposite. The no contact is regarding any third parties of Ms. Betty.
Okay,
Let me do it this way. Ms. Betty, you receive your property next Thursday, everything goes swell, you're moving on. Is there any reason
Correct.
to contact any of Mr. Parent's family or Mr. Parent himself?
I didn't hear that last thing, Your Honor. Could you repeat yourself?
Is there any, so assuming the property transfer goes well next Thursday and no issues, you get all your property, it's all said and done. Is there any reason for you to reach out to contact Mr. Parent
Oh,
or Ms.
no, no, sir. No, sir, not at all. No way. No, sir, not at all. No worries there.
I can't order it, that's not before the court, but I'm going to tell you, if you want peace of mind as well, just get your property next Thursday and walk away.
That's exactly
No
what
contact with Mr. Parent, no contact with his family. It makes it simple. You
Yes,
go your
sir.
separate.
Yes,
And that's
sir.
what we'll,
Absolutely.
well, Mr. Parent, you're all set. Ms. Betty, you're all set. You're both.
Thank
ready to go. 949 DM. This is the defendant's motion regarding domicile, custody, and support as well as parenting time. Mr. Murray appears by the Zoom application. He's in pro se. Sarah Murray is present before the court as well. She's in pro se. Will both parties please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I do.
I do.
Thank you. You may both put your hands down. Mr. Murray and Ms. Murray, we do not use the children's names. You can use initials if you wish, but we don't use the names in open court. But Mr. Murray, you are asking that the domicile of the minor child change to the state of Texas, and you wish to have physical custody of the child, change parenting time, and change support. Is that correct?
That's correct.
What is the proper cause or change in circumstance warranting a review of the custody factors in this case?
DMJ has been
Yes.
exhibiting certain behavioral issues every time he leaves my presence, like for Christmas or for summer. he's been having a lot of behavioral issues, and it seems to continue throughout the year. It doesn't slow down. So the mother and I got together and figured out maybe he would thrive better under my parenting.
So you've discussed this with Ms. Murray?
Yes, sir.
And is there an agreement?
Yes, sir.
What is the agreement as you understand it?
That we would be, I would be taking custody over DMJ, leaving AM behind, splitting the children basically, to see maybe if that'll change the behavioral issue.
So obviously that would potentially be physical custody. What about legal custody? Legal custody, decisions, religion, education. Is it currently joint between the two of you?
Yes, Your Honor.
Would that remain?
Yes, sir.
Okay. And bottom line, do you think this is in the best interest of DMJ?
I do believe that I have some level of parenting skills that
I'm not saying that. I'm just talking about, I think it's in his best interest that he may thrive as a result.
I think he would thrive. I do think he would thrive. I just believe that he's truly missing me, and that maybe some time with me might help.
All right. What is the parenting time arrangement then?
Currently, it's just the summers.
Right. No, I'm saying if custody were to change, have you discussed what parenting time Ms. Murray would get?
She would get the summers, just like I would. It would be like 1 year on, 1 year off. We'll figure out whether or not we'll be in Texas or Michigan those years. That way the children get to see
mom. What do you mean by 1 year on? What do you mean by 1 year on, 1 year off?
Like 1 year I would spend time with DJ and Anna, and 1 year she would spend time with DJ and Anna. I would try to figure out a way.
For the whole summer?
We haven't quite gotten that far yet. It is a big difference between Michigan and Texas, traveling arrangements and whatnot.
What city are you? What big city are you nearest to? You're in Amarillo.
We are in Amarillo.
So you're on the west side, correct?
Yes, sir.
I drove from Houston to Michigan. That's a long drive.
Yeah, it is a very long drive.
So, well, let's begin with the physical and legal custody aspects of this. Ms. Murray, you're under oath. Did you hear the testimony by Mr. Dean Murray, the petitioner?
I did.
You in agreement with this?
It's been an ongoing conversation of 2 years.
Okay, but that didn't answer my
Oh,
question.
yes, I am in agreement.
You are in agreement with this. Do you think it's in the best interest of DMJ that physical custody change from you to father?
Yes, I do think you've done that a lot better than you wanted to.
Okay. Parenting time. How do we do that? What do you suggest?
I would just suggest, we would make an agreement ourselves like we have been and do the summers like we have been with the last couple summers.
So just simply flipping it. So what Mr. Murray had, you would get,
Right,
and vice versa.
unless if we come on agreement. Other.
Ms. Schultz? I want to make sure that we make this item plan so you're not getting 30 phone calls or texts a day.
I believe what the parties would like the order to reference as it relates to DMJ is that Ms. Murray would have parenting time pursuant to the long distance parenting time policy. However, they would also like a provision that they may otherwise mutually agree to the parenting time to modify it accordingly. I assume there's some intention that they indeed have time together still, but I'll defer to the parties.
How does that sound?
That sounds like a good idea.
Does that sound good to you, sir?
Yes, sir. Yes, sir.
So ordered. Court finds by agreement of the parties, and they also find it's the best interest of the minor child that this happens, so the court is not going to stand in the way of the parents. They know the child better than the court does, and if they feel that this is in the child's best interest, if I found something that would not be in the best interest of the child, certainly I would pipe up, but I'm not hearing anything at all. So I will grant the motion. Legal custody shall remain the same. Parenting time as outlined by Ms. Schultz will be entered as well. However, support will have to be recalculated, I'm assuming.
There's actually a pending child support review at this point, so we can just update the overnights. From my perspective, Your Honor, my biggest concern would be when this transition will occur, because I don't want it to impact DMJ school.
You are anticipating my next question. Obviously, this young man's in school right now. When is this change going to happen?
We were thinking more along the lines of Christmas time, end of the year, beginning of next,
What
or
about the semester?
summer.
It's right about there, isn't it?
I think the semester change is the second week in December, so just prior to Christmas break. But I don't know what the schedule for the schools in Amarillo would look like either.
Right. Do
Okay.
you know anything about that, sir, regarding the school schedule in Amarillo?
Not as yet, but my wife is looking it up now.
You're not sure?
No, sir.
Okay. Well, let's make it effective at this point. I don't know if I should go Christmas break or if I should go end of the semester.
If the court wishes to perhaps use December 1st, but to coincide with the end and start of the first semester of the academic year.
Does that work for both parties?
It does for me.
Works for me.
Okay, so ordered. Anything else, Ms. Schultz, we need to address?
Makes sense. It's fine.
The court is specifically granting domicile to the state of Texas.
That is correct.
Thank you, Your Honor.
Yep. End of the semester's end of December.
That'd be right before Christmas break.
Mr. Holbrook pulled up the ISD schedule for Amarillo, and it looks like their date would be December 20th, which would coincide with our Christmas break schedule here.
Perfect. Okay. All right, the court will, I should say the friend of the court graciously will prepare the order in this case. Thank you both for being able to agree, and I hope this works out for DMJ and for both parents as well. And by the way, if you're wondering why I was kind of mumbling here a little bit, as soon as I heard Amarillo, I was thinking of George Strait's Amarillo by Morning. You're both free to go. Thank you.
Judge Prill, is there a way for us to squash the child support since we both have one child and if we needed help to ask or no?
No.
What will, may I clarify?
Yes.
What will happen is the overnights for each of the children will be averaged together to have an updated calculation for both children. But we can't stop the charges so long as there's public assistance in place.
But there won't be one he leaves, does that make sense?
Will there not be public assistance for A?
I don't even get anything, maybe they get it, but
If there's any public assistance, there has to be a support order. If there's no public assistance, which would include medical, cash grant, and so on, then there can be a zero support order put in place in that situation. So what we will do is the friend of the court will still run the calculation. If we have verification that there is no public assistance, you can then stipulate to a zero support order. Okay.
Just keep the friend of the court notified of any change of address or employment as well as they do their calculation regarding support. All set. Thank you both. Show cause petition has been filed in this matter regarding Mr. Montgomery. He is in the courtroom. Mr. Montgomery, would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. Please, Mr. Holbrook. Good morning, sir.
Good morning, Judge. Mr. Montgomery was last before me for a show cause on July 31st, 2024. At that show cause hearing, I had a discussion with Mr. Montgomery regarding his non-payment of child support, and he had entered into a payment plan with our office on July 31st, which was attached to the support enforcement order that was entered in August 2nd, I do believe. That payment agreement that he had signed stated that at the time of the show cause, he owed $1,593.64 in past due support, and then he agreed to pay $53 to $105 per week starting August 1st to further reduce the debt. He had signed that on July 31st as well as myself. That was attached to that order. After that show cause, Mr. Montgomery had no contact with us and has not paid a single penny on this account. Currently, it is charging $454.50 per month, with now an arrears of $2,502.64. Due to Mr. Montgomery's failure to comply with the payment agreement, the show cause was for today brought before the court regarding the payment agreement to either hold him accountable for not making those payments or enter a payment agreement that has some repercussions if he does not follow. As well as asking him to update our office with a valid mailing address, as I do see the one that was provided here in bad actually just labeled as bad address, mail was returned.
All right. Mr. Montgomery, did you hear all that, sir?
Yes.
First, let's just make it simple regarding a mailing address. What is your mailing address?
That's the address that as of October 15th came back as not known at address given.
I would go to the post office and file a change of address. So you're saying,
204.
okay.
Yeah.
Well, we'll try it again, but you need to check in with the post office and make sure that all that paperwork is there. Okay, you heard the response, or you heard the comments of Mr. Holtwick regarding the payment plan. How do you respond to that?
Well, I had fire at my house in Elderly, so like I had to restart fire. I haven't really had a lot of money to make that payment.
So I'm assuming you called Mr. Holtwick and let him know of that, so other arrangements could be made, right?
No, I did not.
Why not? All it takes is a phone
Yeah,
call. I mean, if you ignore it, that's why you have show cause hearings
right?
where you can be held in contempt and placed in the county jail. I mean, I don't want to do that to you.
No.
All it takes is a phone call. So what can we do about this?
But yeah, like my wife went to jail. I didn't work for a while. And
I'm sorry, I was aware of that.
Oh, yeah, she's in rehab right now. She will be back in 25th, so my work's not been limited to what I can do. But I can make a payment today.
How much today?
Maybe 50, 60 bucks. I don't have a lot of money, but
And what about the remainder of the payment plan?
I don't know, waiting for the refund. They have my income taxes, but I
Who has your
figured they just
income
take
taxes?
for the court. I figured they just take the rest of it out of there. Like, you know,
Well, that's not gonna happen until next year.
Oh, really? Yeah.
So,
So,
and I mean, you're working, correct?
yeah, part-time, not full-time, like, they assume.
I just have to ask though, why did you arrange a payment plan, not pay anything and just completely ignore it and not let Mr. Holvick or anyone from the front of the court know?
Like I said, I had a fire literally a couple of days later after that payment arranged.
Sure, I understand that, but I remember I was in the second grade, my whole home burned down and I still remember it, but I still have to take care of my obligations.
Yes,
And you do too.
yes.
So what are we gonna do about the remainder? You have a proposal?
Maybe 50 bucks a week, maybe, I don't
But is that
know.
what we agreed to last time? 50 to something per month?
Yes, Your Honor. The last time when I had the conversation with
Yeah.
Mr. Montgomery was entering the payment plan, that's not gonna set him up for failure, something that he can do. And based upon his statements of, you know, how much he brings home at the time. I also believe at the time he said he was staying in a hotel, so he'd have to pay,
Yeah.
you know,
I just got
stay
into a
there.
house.
So we, you know, went over how much he was bringing home and how much he had to pay, and that was something that he could do at the time, $53 to $105 a week.
So you're saying $50 a week at this point?
And just,
Yes,
I just want to put on the record too, Your Honor, Mr. Montgomery did appear today, but not after calling us right at 8:30 or just before saying he can't make it today.
I would.
So he was informed he didn't show up today that the warrant would issue for his arrest, and he's here. So not sure exactly why he couldn't be here, but now he's here. So I guess to me, actions are a little louder than words, and what's been promised us so far, nothing's come through. So
I understand. Can you explain that? Why couldn't you be here this morning?
Oh, I was at work. My van was supposed to be getting fixed. I was supposed to get my brakes fixed. I had to went to work with my boss. I didn't know, like my friend called me and said, you know, you have court today. I'm like, I know I have court on Monday. And I'm like, well, I didn't want to make him drive me all the way back to that. Actually, we were in Harbor Beach.
Okay.
I was calling to see if I could Zoom though.
I guess it's a moot point because you're
Yeah,
here on it.
I was calling to see if I could Zoom, but they said I couldn't Zoom. So then I'm like, all right, can you take me
Okay,
back?
so you can do $50 today.
Yes,
And when can you start the $50 a month payments?
now because I just felt in a hole because I was renting a room and I didn't have, now I have a place to stay. I've been there.
So
for
you
2
can make a
weeks.
payment
Today.
this Friday and you can make one next Friday?
Yes, I can, yep.
Okay. What we'll do though is I'll accept that, but for only 30 days. Within that 30-day time period, you are ordered to meet with Mr. Holdwick to set up a different payment plan to cover the arrearages and make sure we're moving forward. And I'm asking for a recommendation from Mr. Holdwick because I do find him in contempt here regarding the payment plan. I want to put some teeth in this so we make sure that this is taken care of. Mr. Holdwick, do you have any recommendations?
I do, but first, can you repeat that, Your Honor? I caught the 30 days, I didn't catch this.
$50 today, $50 every Friday, every week thereafter for only 30 days. Within that 30-day time period, he is to set up an appointment with you regarding an updated payment plan to cover the arrearage as well as the original support amount, because he'll be then somewhat on his feet. He's at his home now. And we take it from there. But if he fails to do so, I'm asking for a recommendation as to what he would recommend the court do in the event he fails to provide the support.
If he fails to comply, I would say a warrant with, 25% of his arrears. Then we have another hearing, if that's the case.
And the hearing would be when he's in orange.
Correct.
I don't want that. I know you don't want that either. You want to work.
Yeah, for sure.
And I want you to work because that's providing support. So do you understand what we're doing?
Yes.
$50 today, payable to friend of the court's office. $50 each week thereafter.
Okay, understand.
And that I'm only going to allow that $50 per week payment for 30 days. In between now and that 30th day, you are required to meet with Mr. Holdwick to set up a different payment plan, give him all the information, and then we proceed that way moving forward. If you don't set up the payment plan, if you don't meet with Mr. Holdwick or you fail to make any payments moving forward, Mr. Holdwick is going to request and the court is going to enter a bench warrant for your arrest, and the bond will be not 25% of the arrearage, it'll be 50% of the arrearage. So we're not playing games. And it's just a testament to me, hopefully to you, that when you know there might be an issue or a problem, it's so much easier to get on the phone than appearing in a courtroom. I think you'd rather meet with Mr. Holdwick than meet with me.
Yeah.
And I would rather do it that way too. So do we have an understanding, Mr. Montgomery?
Yes, we do, right.
Great. Mr. Holdwick, is there anything else further to be asked of the court?
Not for myself, and Ms. Schultz has some.
Ms. Schultz.
I would suggest when Mr. Montgomery goes to make his payment before he leaves the building, if he's changed employers, he may want to ask for a review of the child support order.
Do you hear that?
Yeah.
You'll do that?
I haven't changed employment. Well, I get less hours, but I still work the same place.
A change in hours may qualify as a change in circumstance, and looking at the last calculation, my understanding is there may be additional children not reflected on that calculation. I would encourage that a request be made.
Hint, hint, hint.
I thought I did. I thought I I filed a motion for that already. I don't know what happened with that.
Well,
Yeah,
you're hearing something
Okay,
different from the friend of the court. That's why they're the friend
yeah.
of the court. You're out of here, Mr. Montgomery. Make sure you make that payment and follow through with what was suggested. All right, good luck. This is Ms. Brock's motion regarding parenting time, taxes, as well as legal custody. The parties are present. They are in pro se. Would you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God? Yes.
Yes.
Thank you. Can I hear from the front of the court first? Start.
The last order that the front of the court records show is an order that had entered in Sanilac County prior to transfer to Huron County. And that order granted the parties joint legal and joint physical custody of the minor children, both S and L. Mr. Miller was granted parenting time on alternate weekends from Friday at 5:30 until Sunday at 5:30, as well as an alternate midweek visit on Wednesdays overnight on those weeks that he did not have time. To correspond to the off weeks when he did have weekend parenting time. During the summer break, he is granted parenting time from Tuesday at 5:30 until Thursday at 5:30, as well as alternate weekends, Friday at 5:30 until Sunday at 5:30, as well as alternate holidays, and 1 week of parenting, uninterrupted parenting time. So.
Okay, thank you. Ms. Brock, you want to change that. And before we, again, just a simple disclaimer, please do not refer to the child's name, just an initial.
Okay.
And this is primarily regarding S, correct? Or is
Yes,
it both?
it's primarily S.
Okay. So, Ms. Brock, what are you requesting and why are you requesting?
I wrote a statement, I'll read that. When Ryan and I first went to court to establish custody of our children, I had a feeling that he should not have the children much, and I was nervous to let them be around him alone, but I thought that Ryan would have to step up to the plate and turn into the father and the co-parent that he needed to be. Right away after the judgment, things went south and I ended up getting more custody of the children. Since then, Ryan has continued to disappoint. He puts in minimal time, effort, and money towards his children. He tells me that I have enough money, so why should he have to pay? He rarely attends his children's school events or sports, and when it is his day with the child and they have an event, either myself or his mother usually gets them to where they need to be. Ryan also continues to blame me and my family for him not being able to get a job because he has assault charges on his record. I believe that Ryan is an alcoholic, and over the years, it's only gotten worse. He can become mean and angry when drinking, and my daughter recently experienced this while on a camping trip with him. About 2 months ago, Ryan told the children in front of me that he cannot be a parent anymore. He's moving out of state and he's signing over his parental rights, and that the state is making him do this. This caused my son to be very upset. A week later, he acted like nothing happened and wanted the kids back. Ryan says and does many things like this that mentally affect my children. My son still wants to be around his dad, and I do not want to destroy any relationship that they do have. But I do believe that Ryan has mental and addiction issues, and therefore that's why I proposed the motions that I did today.
And what is your proposal regarding parenting time, legal custody, as well as the taxes?
Yes, and so the parenting time with my daughter, I don't want to change it, but I do want to make sure, well, for my daughter, she's almost 13. I want to let her have an option if she feels safe going or not. I don't know if that's the thing, but it's hard for me to want to take away parenting time.
Right.
But at the same time, it's hard to let her go sometimes.
I cringe regarding having the child to decide because, and the court doesn't have the authority to have the child to decide because the child can decide, you know, for instance, let's assume she's 16 and that's that age where they want to go party with their friends and do their thing. And well, I don't want to be at dad's this weekend. I want to stay with mom, but then she decides to go and party and all that good stuff, and then problems happen.
Yeah.
I will not allow at this point any child to make that decision. It has to be the parent's decision. What I mean by that is if mom thinks it's unsafe or dad thinks it's unsafe, whomever it may be, obviously you have to do what you need to do to protect your child or your children. But to put that burden upon the child, herself or himself, not a good idea. But so do you want to continue the parenting time or you don't want to? Because it sounds like you wanted to have sole legal custody as well.
I feel like I do all that already. I make pretty much every decision for my child. So I just figured why not enforce it? If something major were to ever happen, I feel like I'm the one that already does all that anyways. So yes, I did want to have full legal custody. And then my other proposal was, because like I said, I don't want to destroy my son's relationship with him. He loves his father. He wants to be around him. But I also have that feeling like I hope they're safe when they're there. So I was proposing that maybe there has to always be another responsible adult when my children are with him.
Okay, let me ask this question. When the court in Sand Lake decided joint legal, joint physical, was that based upon a trial or was it based upon an agreement reached between the parties?
It was an agreement.
Okay. And at the time the agreement was reached, were there issues regarding substances of the father?
Yes.
Well, then it begs the question then, what has changed? Why would you agree to something like that, especially when the children were a little bit younger, that you want to do it now?
I think I just always had the hopes that he's going to change. He's going to get better. And now that I'm not going to be around to be the mom there all the time and the kids are going to be with him, in my mind, I'm like, he's going to have to step up and be that person. But it didn't happen.
Is there anything in the judgment that prohibits the consumption of alcohol by a father during his parenting time?
No.
When the child or children are exchanged, do you do a face-to-face exchange or is it just, you know, you drive the car
Usually no.
The children get out?
Yeah, no, it's not face-to-face unless he comes like out of the house to talk to me.
Okay. Are you able to speak with each other?
We try.
Okay.
It's difficult.
I understand. What about taxes?
So to me, it doesn't make sense how somebody can get to claim a child when they don't pay child support on them all year. And then use that towards their arrearages. To me, I'm the one supporting my children like fully right now. I pay for everything for them. So to me, I don't understand why he gets to claim a child if he's in arrearages up to like $5,000.
Well, let me check. Does Supreme Court ever report as to what the arrearage may be?
We just had court last week about this, Your Honor. We were here last week about it.
As of right now, Your Honor, arrears is 5,411. However, that is subject to be reduced. There was a $150 payment that was made last time we were in court, and earlier this week, Mr. Miller came into the office and made a $410 payment. So he will be over the monthly obligation of the 508. So there will be a reduction of the difference, but just looking at it real quick, not exactly sure that.
And just remind me, and this may be a Michelle's question. When you get to claim a child, ballpark, what is the tax number? Do you have an idea, Michelle, as to one child?
It depends on if you're eligible for any of the associated child tax credits that go along with that, but your exemption amount, I believe, is $2,800 per child. And then the credits are an additional amount above that, up to approximately $3,600. But it depends on your personal income.
Thank you. That's a big amount, obviously.
And like I said, if he's caught up on child support, absolutely, we should split it. We should each claim a child. That makes sense to me.
And that's what was agreed to in the original judgment.
Yeah.
All right, anything else you want to say? Ms. Brown?
There was also that portion, I don't know if this is involved today, but my daughter did just have to get orthodontics done. She's getting braces on. I paid everything in full after my insurance covered what it covered, and I paid it in full to get the reduced amount. And then I figured out what he would owe based on our court orders. I had him sign an agreement that he would pay me $50 a month for that until it was paid off, and he has not yet done that.
Okay. Have you notified the friend of the court of that
Yes.
issue as well?
Mm-hmm.
Because it remains, you have to do that within 6 months of service.
Yep, the motions were filed along with this.
Okay. Okay. Does that cover everything at this point?
Yes.
Okay. Mr. Miller, your response.
I do plan on paying her this month, end of this month, $50, what we did agree on. I have been trying to catch up on child support here. Some of the things she said, I mean. So the child support is about the child is when I claim one child for the tax season and I receive a refund, what I get for my children and whatever else, I let her take it all. That's to catch me up on child support. So as I keep going at the rate, I kind of figured it out. If I keep going at the rate and then she gets my taxes at the new year this year, I should be almost caught up.
Would it be easier than just to change it where she claims both children?
Well, no, because then I don't get, then she's still collecting the same amount of child support. And then I can't give that money to her to knock it down.
But we're talking arrearage nearly $5,400.
Yes, sir. I understand that. And like I am doing, I'm getting back to things now going on. I just, I got this in here too. Like I am filing for full disability. So I will have, you know, a fuller income of like almost $3,400 a month or whatever the full disability is through the military.
Anything else to respond to this?
Then, so Steffi threatened the children full time. This has repeatedly happened. This is not the first time okay, well, I'm not.
No, you're speaking to me. You're not speaking.
So for my child, yes, sir. So like my child and Landon, as she said in her statement, that she feels that it is in the best interest of our daughter gets to make the decision. And I feel like she always is putting Landon beside. And I do.
Please don't use the other child's name.
Oh shoot, sorry, sir. It's just a bad habit. But for the sporting events, I attend as much as I can to the sporting events, but I don't see why any reason not showing up for a sporting event has to do with taking the kid full. I don't understand. Like,
are you exercising your parenting time as ordered?
Yes.
Okay.
And she's asking for more time and letting Savannah make the issues. That's her choice. The insurance is under her name, sir. I've had these kids for almost 5 years and they have never had a single scratch or a mark on their body. And there's never been a reason for it.
Well, that's not being alleged. It sounds like the issues are possibly alcohol.
I haven't had a drink in 20 days, Your Honor, and I've been sober, and how would she know if I have a drinking problem or not? I haven't seen her in 5 years besides dropping off kids.
What about the camping trip? Do you have any response to that?
Yes, I do.
Did you make the comment regarding I'm signing off my rights and all that?
No, sir, I did not say it like that at all. Okay, so I'll get to the part, I'll read this right here, sir. Stephanie threatened to take the children full time. This repeatedly happens. I took the children into the room and explained that their mom was going to take me out of court or take me to court, and it will be up to the judge to decide. I told them if I couldn't see them anymore, I would have to leave state to get a job and try to do something different.
Okay,
I would come back.
Let me interrupt. This is said to a 13-year-old, and what's the other child's age?
10.
10? You're sharing adult information like this with 2 minor children?
Well, because we had court, sir, coming up.
Oh, I understand that.
And she already tried to.
Excuse me, sir. You were talking about adult-related matters. If you were the 13-year-old or the 10-year-old, and you were hearing this, wouldn't that scare you?
I'd feel sad, sir, yes.
So
but I didn't know when this.
Why would you do that?
Because I didn't know when this was going to happen. Like, she's already tried taking me to court for full custody, legal guardian. She's already done this like a year ago.
But let me suggest something. What about this? Your mom and I have some differences.
Right.
We love you both very much. And regardless of what may be going on, we're going to do our best to do what's best for you. And then you argue with the court outside the presence of the children and do it that way, rather than saying, well, mom's going to do this or dad's going to do that. You see where I'm coming from?
Yes, sir.
I
may have made a mistake. I should have went about it differently.
I'm not here to judge about who made mistakes. I'm just talking about if you were a 13-year-old and a 10-year-old, how would you take that when you hear that information? And that's
I would take it sadly, yes, sir.
Yeah, okay, and I appreciate you noticing that, because whatever differences you've had, and again, I didn't preside over the San Lac divorce proceeding.
Right.
But I say this after every divorce proceeding. If you have minor children involved, you have to work together on a united front. You may absolutely hate each other's guts, and I understand that. But when it comes to the children, you must be able to talk to them in a way that doesn't make the other parent look bad, make yourself look bad, or try to pit the children against either parent. That's where I'm coming from.
Yes, sir. And I did not pin her. I never say anything bad to her about the children at all. I never have.
Okay.
So in the very first settlement of our divorce, we came to terms. I had the kids, we pretty much did like a 60-40 schedule. That was the plan we were going to do. And then we followed all the paperwork to do this, and so in doing so. Okay, she willingly knew everything about me, every incident that I've been in trouble with, everything from the get-go. Only if she would do the 60-40 and $300 a month child support when it was supposed to be almost $900. She agreed to switch weekends where she could have alone time with her spouse. So I gave up my spouse and her child for a little less child support and get her free weekends. She opted and agreed to that. There has been nothing that has
been ordered by the courts.
Has been ordered by the courts, and nothing has been changed since then. I have done nothing like in ingredients to do that. My kids have never left my house and had a single scratch on them. Now I can't say the same for her, but she does do this, or she does do a lot of the medical because she has them and she makes the appointments on her time. She has never in 5 years asked me to take the kids somewhere. And if she did, I don't remember it. And if I didn't do it, there was obviously a good reason for work or a hospital visit or a VA visit, an appointment or something.
Okay, well, let's cut to the chase here.
And then can I say one more thing, Hunter? About this case. Like, she also has taken me to court already and threatened me to take the kids for full custody, full everything, and had
for this court or the previous court?
The previous one.
Okay. Well, we look for the last order moving forward.
I know, but nothing has happened. Nothing has changed. Why did she try to do this when we already fixed this once already?
No, I've never tried to do that. I've never tried to take the kids full custody, never.
Okay.
It's in there. I think we have it.
Regarding legal custody then, sounds like Ms. Brock wants to have full legal authority regarding medical, education, religion. How do you feel about that?
I disagree.
Okay.
My kids have gone to my church more than any church he's ever gone to.
My next question is, you stated you have not consumed alcohol in 28 days, correct?
20 days, sir.
20 days, okay.
Yeah.
Well, when you back up 20 days, the camping trip was early September, September 1. You were consuming alcohol then, correct?
I might have had a drink or two, yes, sir. But I didn't think that was against the law.
I'm not saying that.
Oh.
But that's what's being alleged by mother, that there's an issue regarding alcohol.
Yes, sir.
Here's what the court is going to do. There must be either proper cause or change in circumstance to warrant a modification of custody and or parenting time. The standard is a little bit more relaxed for parenting time, but legal or physical custody requires the Varga standard. And that is again, change in circumstance, which I've defined numerous times previously. I don't find, in this case, any proper cause or change in circumstance regarding custody or parenting time. However, what I do find is that as it pertains to father's parenting time, he is not to consume alcohol 8 hours prior to or during the time that he has the children. If it is discovered at exchange that father is under the influence or appears under the influence, and mother decides to disobey the court order and take the children back, she'll have to show what she believes would cause her to take the children back for safety purposes. But I will not allow any alcohol or illegal substances to be consumed by father during his parenting time, simply put. By doing so, that ensures that the focus is on the children. And if there are any issues, and I'm not saying there are,
Sure.
but if there are issues relative to alcohol, at least they won't be during the time that father has the children. Regarding the taxes as well, I have been contemplating this, and I need to speak to Ms. Schultz about this, because I think it's something that I would like to do moving forward. We are starting to see more and more the arrearages of parents in support matters to increase. Now, mind you, we have the economy, which is, some people may say is in the tank, and some people, I mean, just going to the grocery store is crazy nowadays. And support is getting ignored. This court is contemplating moving forward, and I'm not going to do it in this case at this point, but it's going to be considered by the court moving forward, if I'm allowed to do this, that if there's an arrearage regarding payment of support, and there was a prior agreement regarding tax returns that each party alternates, the court is going to mean that if there's an arrearage going on, and one of the parents says, well, hey, I want to play my deduction. If you're behind in support, the court may order in the future that you don't get the tax exemption. And by doing so, and if I'm allowed to do so, I have to check the law on this, but I'm tired of seeing these arrearages. I'm tired, and again, I've heard the story time and time again, well, you know, I have bills to pay, I have this, I have that. I understand, but our support formula, this handy dandy green book right here, says that your expenses and your mortgage have nothing to do with child support. It's based upon your income, and it's based upon the amount of overnights. And so I guess I'm putting all individuals on notice that this may be something the court looks at in the future, because these children have to be supported, period. So, in long and short of this, regarding the motion regarding taxes, the court will not grant the motion at this point. However, I'm putting you on notice, sir, that if this continues and another motion is brought, the court may change it. And she may be able to claim both, and that may continue so long that there's an arrearage.
Yes, sir.
Do we have an understanding?
Yes, sir. Can I also make a few more statements, sir?
Well, I've decided the matter.
Oh, what's that?
I've decided the matter.
Oh, I was just saying, can the drinking thing go with her too, the same as she would not be able to lie, because she has a drinking problem too. She drinks every day. The kids
You
have
can
told
file a
her.
motion for that if you wish to. That you've not alleged that. You've not
Okay.
said anything until now, and it's not before the court.
Can I please do that though? Like today after this
You can
court, I
file
can file a
whatever you
motion
want.
for it?
You can file
Okay.
whatever you want, but make sure you file the motion, you have proper grounds to do so.
Yes, sir.
That's how we'll leave it.
Okay, thank
You're all
you,
set.
thank you.
It's time date set for show cause regarding Ms. McGuise. Ms. McGuise is not present. The court looked at the Zoom application, inquired of Ms. McNave whether or not she may have checked in via Zoom this morning. She's not checked in via Zoom. She's also not checked in person. As stated, the matter is scheduled for 9 a.m. It is currently 10:48 a.m. Mr. Holdek, you may proceed.
Thank you, Your Honor. We were last before the court on September 13th, 2024. Mr. Guys did appear for that hearing by Zoom. At that hearing, the court had given her approval to appear by Zoom because it was a last minute request. She had reported at that hearing that she has not been working since August 31st of 2024, and that she has not been paid from her previous employer since August 31st of 2024, but that she should be paid very soon. The court had ordered that myself, I would contact Mr. Guys' adult probation agent and obtain further information of her situation. She was also to provide our office updated medical documentation as to why she was not able to attend the July 31st show cause. The documentation that was provided, the court had found was inadequate. So the court had adjourned the show cause from the 13th to today to establish payment plans and to establish why Mr. Guys did not follow the payment agreement that was entered previously of $170 to $200 per month that was ordered in June 25th, 2024, as well as contempt proceedings that would continue at today's hearing. The court also ordered that Mr. Guys make the payment prior to today's court hearing. From the last court order, Your Honor, the firm of the court has not received any updated medical documentation from Mr. Guys. There was a $50 payment on October 3rd of this month. The current case has had a total of $1,257 charged in child support since November of 2023. And we've had a total of $226 paid since November of 2023. As of now, her arrears are $995.50. It will be $1,048.50 if there's no further payments for this month. I did hear back from her probation agent the following Monday on September 16th, and he had reported to me that Mr. Guys missed the report date with him. He went to the home, found out that she was not staying at the listed address she was providing to her probation agent. He had a report and found that she was using drugs again, then stated that she needed rehab. He also stated that he got it added to probation that she must complete the rehab and believe she'd be in rehab for roughly 30 days. After that, she was requesting a halfway house to continue treatment. And as far as work goes, he stated that her job was under the table, and anytime he would ask for verification, she would not provide it. So that is the update on the case. She is not here. I am not for sure with confirmation if she still is in treatment as to why she's not here. So I would defer to the court as to contempt for not complying with the orders.
Is she essentially AWOL from adult probation?
I have not heard from the agent since then. I can always inquire of
But
that.
as of the last report,
That's right. Nothing. We had a mail-in payment of $50, and I mean 30 days from her treatment. She was in that prior to September 13th. And she had completed all of that. She was been out by now, but we have not had any contact with her.
court will issue a bench warrant for this individual's arrest. The bond will be set at $12,500, 10%. You'll prepare that?
Yes, Your Honor.
Thank you, Mr. Holden. That'll conclude the proceedings. Off to the